This is Beyond a Reasonable Doubt with your hosts, Mark Garrigus and Gary Smith.
Welcome to my favorite 15 minutes in the universe. And I'm smiling ear to ear. Normally, I would attribute that to Awesome Dawson's introduction. But today, I want to give a hat tip to Mike August, because Mike, minutes ago, sent me over what may go down in the pantheon of BRD's favorite little sound bites. One of the things we like to see here is lawyers doing their best work. And this, Gary, do we have his name?
We do. Albert Watkins. I knew you'd ask, so I checked it out.
Very good. Albert Watkins, hat tip to you. Anytime you want to come on, anytime you want to join me, do it. Gary, let's take a look at Albert. Or do you want to set it up as to Albert's client?
We got to set it up a touch here. We've talked about his client quite a bit on the show. His client's name is Jacob Chansley, and he is best known as the QAnon Shaman, or what was Adam calling him for a while? The Viking, QAnon Viking? I don't know. But nonetheless, you guys all know who we're talking about. So this is his lawyer speaking on the heels of his getting a 41-month jail sentence.
After spending this much time talking to Jacob Chansley and learning about him, what do you think is appropriate accountability for former president?
What do I think about his what?
What is an appropriate accountability for former President Trump?
Well, if you're asking my opinion, my opinion is meaningless. I will say that I would probably be far more effective over a beer with former President Trump, even if he didn't have a beer, because I understand he doesn't drink beer, but I'd have a beer. And I'd tell him, you know what? You got a few fucking things to do, including clearing this fucking mess up and taking care of a lot of the jackasses that you fucked up because of January 6th. Now, in the meantime, I might talk to him about some other things that I'd agree with him on. But my opinion doesn't mean shit.
Okay. I may, we do the National Trial Lawyers Convention every year in Miami. I seriously may nominate him for lawyer media person of the year.
I'm so in love with it that I can only react with a sound effect. That guy's the
what I really wish we would segue to, I should have told you this, is Matt Damon on Saturday Night Live. Doing Kavanaugh. It would have been a good, if you edit this, you can segue from that to Matt, which I like beer. Anyway, let's move for a second to what everybody's talking about, which is the Rittenhouse case. Couple of things that happened today. The first of which was somebody who claims to be a stringer. A stringer is kind of a freelancer or somebody who's working for kind of on a per project basis for NBC News and specifically MSNBC, was apparently pulled over following the jurors' van. One of the things they do in these kinds of cases is when don't sequester the jury and you've got a lot of activity around the courthouse, they will have jurors go to a remote location, park there at the beginning of the day, send a van over, pick them up, drive them into the courthouse into a secure area so that they can be escorted up to the courtroom. And then obviously in reverse at the end of the day, apparently there was this woman who was following them, ran a red light, if you believe that.
I believe it was a man, and it was last night as the jurors were leaving, I believe.
Ooh, I like that. Well, all today shows you what you can believe about the media, because all day today they outed some poor woman.
Okay, so the woman that they outed is the person that the gentleman who was pulled over invoked her name as his boss, his superior in New York, and the judge said her name in open court, repeated the statement that the gentleman who had been pulled over gave to police, and that is when the media started going after this woman. She took down all her social media. I love when you fact check me.
Now tell me, the guy who was following claimed he was a stringer, or NBC was just trying to throw them under the bus?
I believe, I'm not sure if he necessarily used the word stringer or associate producer, but your description of what he claimed his job was is correct. He was describing himself as what is commonly known as a stringer. He was working for MSNBC. He reported to a woman in New York, and, you know, he claims that he was just told to follow the van and that was it. But, you know, that's certainly not a good look for a news organization.
And consequently, the judge barred MSNBC from the courtroom.
Correct. And the woman whose name he outed immediately took down all of her social media, but, you know, not before the internet could get there and take screenshots and all of that. So it's that's a
which
wild
has now fueled all kinds of, on the left, my side of the aisle, we have apparently gone psycho, because this just shows that this judge, I saw a Twitter the other day that I actually thought was funny, that the judge had declared a mistrial because he disclosed that Kyle Rittenhouse was his son, and it got a lot of action. But so the left has gone crazy because barring MSNBC now shows that he really is a closet Trump lover, because he's got Lee Greenwood's song on his phone when it rang. And
what other conclusion could you reach?
Right. I mean, it had to be. Not the fact that that judges. I mean, let me posit a different scenario. A judge has got a jury, and a case that involves potential life sentence, and wants to protect the integrity of the verdict and his jurors, who he didn't sequester, which is what you want to take issue with. I would take issue with, but. His kind of punishment pending doing an investigation, and not by him. It would be inappropriate if he did the investigation. He said he was referring it to the authorities, and pending that, he was going to bar them from the courthouse. I don't know what that really does, because basically, if you're live streaming the trial anyway, it doesn't matter if you're in or outside. And by the way, in every other trial I've ever been in, there's always a adjunct room, meaning a spillover room, when you've reached critical mass in the courtroom itself. So for all of those who are clutching their pearls, he really didn't do that much. But the one I will have a little discussion of is, apparently, if you believe what was reported, one of the jurors asked to take home what you and I had talked and Adam had talked. The first two questions this jury had asked is, can we have another copy of the jury instructions, which were apparently 36 pages, actually kind of light for a case of this nature. And they did that, and then they came back and asked for copies, which would you would presume means that everybody in that jury room wanted a copy. This juror today asked if was it a she?
Yes, I believe it was.
I can go to Gary for my facts. She asked if she could take it home. The defense objected. I think rightfully so. I will tell you why. I can remember in the Peterson case that two of the jurors were excused when they were outed for going home and doing research. One juror had Googled something. Another juror had done some kind of investigation. The problem with allowing somebody to take jury instructions home, I've seen a lot of people on the internet, lawyers included, who are saying it violates Wisconsin law. I looked at that statute and what they're saying. I don't think that statute covers this, because it's doing research outside of the instructions or the facts in the case.
I can read you the quote that people online are using often. It says, it's from Wisconsin criminal law. It says, do not consult dictionaries, computers, electronic applications, social media, the internet, or other reference material for additional information.
Correct. I don't think that applies to this situation, because the jury instructions have already been given to presumably everybody in the jury room. What it does, the problem it does present, is if you're telling somebody they can take a instruction out of that jury deliberation room, you are creating a mischief, because that is only one step removed from, okay, you can do something outside of deliberations. You can, that's not kosher. You should be able or the instruction to the jurors is, and what is the kind of age-old maxim is, the only time you're supposed to be thinking about this case or discussing this case or doing anything is when all of you are together in the same room,
Right.
as a deliberation or a deliberating body.
Well, I would also think that it, is if you're going to take material like that home, it would be of a human nature to share with the people that you share your domicile with. I mean, it would be hard to avoid it.
Well, I know what I do. If I go home and I've got a dense or a kind of ponderous language, and the judge has already described it as such, and clearly anybody who looks at the instructions would agree with that. One of the things you're naturally going to do, especially if you're on a computer or iPad, if you've got language that you're struggling with, you're going to just copy,
paste,
and look up.
Mm-hmm.
And boom, as soon as you make that move, as soon as you copy and do paste and search, you violated the judge's order.
And for so many of us, that is of such a second nature to do a search when you don't understand something. I mean, it doesn't occur to you, even if you've been specifically told not to do it.
Right, because you're absolutely right. That's exactly, you put it more articulately than me, but that's exactly the problem. Right. It creates mischief. And the defense objected, he overruled. And for those who think he's a pro-defense judge, which I laugh at because this judge already has reputed to be, I don't practice in front of him, but those who do say that for 25 years, the defense bar basically tried to put him out of business. And so don't give me that.
Yeah, you sent me an article, a front page article on a Kenosha paper saying just that was dated from 2006. So he has not necessarily been a friend to the
to the accused.
Yeah,
to
correct.
The accused. And right. By the way, I read another article today, which I wanted to try to debunk, which was a guy that I respect quite a bit, who was quoted liberally through the article. And he, like I, said, no, this idea of prohibiting victim is something that has been in the law for a long time, and it clearly has. I mean, depending on what state court you practice in, this is something you don't call somebody a victim because that presupposes that they have a status, which is that a legal status.
Correct.
Just as you can't call the accused a criminal. That's for the jury. You're supplanting the jury role. But they were taking issue in the article with the idea that the defense would be allowed to accuse the people who were shot or killed, characterize what they were doing. I think that's a distinction. You're in the closing argument. The evidence has been presented. Part of what you're supposed to do is infer, suggest, and tie the case together for the jury so that they can get your best view. Closing argument is not evidence. Opening statements are not evidence, but they serve a purpose, and the purpose is to tie the evidence together to give the jury some roadblocks and some other stuff. By the way, there's also a lot of speculation on the internet of why isn't it a fast verdict? Who does that favor? Obviously, I've seen a lot of commentators say it's clear that they're going through deliberately in order to convict. I don't buy that either. First of all, it's incredibly hard to predict what a jury's going to do. Second of all, in a case like this with this kind of attention, and when you have deaths, jurors take their job seriously. Yeah. They've got these ponderous, dense jury instructions. They're going to go through it. They're going to try to understand it.
All right. Well, I have two more questions for you that are somewhat on this topic, and I'm going to combine them into one, and then I'll let you address, and we'll get out of here. It is being widely reported that one of the defense attorneys said loud enough for people in the media to hear that he believes that the jury is tied deadlock 6-6. What do you infer from a defense attorney saying that loud enough for the media to hear it? And B, longtime listeners of Reasonable Doubt will know that Mark is a big proponent of verdicts coming back Friday afternoons. With Friday afternoon right around the corner and Thanksgiving looming large, do you have a sense or a prediction you'd like to make about when this verdict will in fact come down?
The prediction I will make having tried a gazillion cases, I knew this would not be fast. For those who were saying it was going to come back fast, I just don't buy that.
Your friend Adam, by the way, is perplexed by this. He wants an answer. He wants the verdict.
Yeah, everybody wants the verdict. Now, jurors, when they go back there, and when there's death involved, are going to take their time, especially with these kinds of instructions. These kinds of instructions require jurors to do mental gymnastics, and they take it seriously. Now, if there is no verdict by tomorrow, today is Thursday, by tomorrow, Friday at 3 p.m., and I'll tell you that's my bewitching hour, and they get recessed for the weekend, this is a hung jury in the making.
Okay, there you go. You heard it here first. And we will be back with a Best Hour in the Universe on Saturday this week. We'll be recording it tomorrow, and we'll see if we have any updates to give you on Rittenhouse or anything else going on.
Shout out to Lynette Carolla for taking you to dinner.
Absolutely, yeah. Lynette took the whole staff out to show her appreciation and kick off the holiday. So thank you very much to Lynette. And Mark, thank you for making the time so late in the evening for me.
I wish you'd brought the little one, but it's okay. Next time.
He was in here earlier, but we had a little bit of a tech issue, so got delayed. But Mark, great to see you.
Well, tell him Uncle Mark says hello.
I will. Thank you so much, sir. All right, I'll see you next time. Bye-bye.
Bye-bye.
Thanks for listening to Beyond a Reasonable Doubt. Stay tuned for more bonus episodes coming soon.